for, who actually originally did the document, and when the solicitors complained to the court about it in the instance that I was involved in, the other side then presented a case to the court and said that actually the other expert had limited typographical skills and therefore the typing had been done by the solicitor. Sorry, was there
I was just wondering whether sharing with the instructing solicitor require the other expert consent, whether, out of fairness, I guess because it was something that was discussed as jointly, whether it would require consent of both parties for them to be shared, but it sounds that doesn't.
I would share it as a matter of course. In fact, if you try and put the different parties in a straight line, you've got the two experts talking to each other and the two instructing solicitors behind them. So in other words, whatever comes through to me, I will pass on to the instructing solicitor, and I will tend to, but the instructing solicitors should not be having a separate dialogue directly themselves about it. You are in control of this part of this process, and you need to retain that.
But what I was getting at, do the rules say anything about the experts agreeing on whether the document is out of politeness, if anything else, so that it is not a surprise and one says, well, where did this document go to? And there was a discussion between you two.
It is intended to be a discussion between the experts. And although the solicitors, as David outlined, can have an input in making sure there isn't duplication or confusion that is going to come out of it, and that you've actually properly talked about the individual issues, that is in an advisory role, and it is the experts who determine what is in the document. And it's them who sign it off, them who take responsibility for it, and them who will have to answer for it to the judge in court when it comes to the trial.
So they should be concerned about the form of the joint statement. You should be concerned about its content.
Okay.
I just had a situation where the expert on the other side started off by being terribly condescending. Sent me a draft.
Actually, we're just about to come to that. If you come on 2 slides, I'll say be friendly but not too nice.
Well, you gave me some advice
Yeah.
the other day, anonymised email. We've got to a situation that I amended it because there was too much. I've been around for 50 years and I know everything there is to know about this. I put a line straight through that. That he's refused to engage, making accusations about my credibility, etc., to his instructing solicitor. My instructing solicitor is preparing a document for the court to set an agenda for us to respond to, and I'm sitting waiting to see what happens. But it's been
to my mind, to pick up on what you've just said, it is really, you've given your CV as part of your report. Let that stand up for your qualifications.
Absolutely.
You've been chosen by the solicitor, you're there as an expert, appointed by them. It is therefore very important that you rise to the occasion and are as professional as you can be in the circumstances. And I wouldn't actually worry about, if he wants to blow his own trumpet in the expert statement, it will look ridiculous by the time he comes to the court. It will be sad because it probably will not be such a good document, and you might suggest to him that he doesn't put it in there. But my advice would be is if he wants to shoot himself in the foot, let him. You're not responsible for the other expert as part of this process. But the next slide we put together was be constructive, which really picks up on this point specifically. And the important words here are probe at the end of the first line. The experts meeting is a very useful opportunity to probe where the logic comes from that he is either disagreeing or agreeing with you on a particular point. Probably no need to do so if you're agreeing on a point, but certainly on points you disagree about. And find out what it's based on. It may be because he has a specific axe to grind. It may be because he has a specific set of experiences that are different to yours. But it's very useful for you to understand where he's coming from and what the logic is to his views, because it enables you to deal with them and perhaps come up with arguments that actually support and add structure to your own particular views on the case. The next point, or the next words that I thought were particularly helpful was, be wary of people who are too nice, helpful, or naive, who come into the meeting and say, well, really, I don't know anything about this. You tell me what your views are. And after 45 minutes, you've told him everything that you feel about it. And you haven't really understood anything about him or his views on it. And then you get subsequently rather kiboshed by an expert's memorandum that gives a lot of views that actually he's now had a chance to think about. And finally, always be wary of any expert who goes into a meeting and criticises their instructing solicitors. It's one of the sort of the guidelines. Don't criticise your instructing solicitors, and be very wary of somebody on the other side who is saying that they haven't given him the evidence or they haven't actually supported him adequately in preparing for the meeting. So the words that I want you to take away from this are: be firm, be positive, be constructive, be professional, most importantly than anything else. And for those of you who are members of professional institutions, such as surveyors or doctors, but you also have to hold with what the rules are of your professional institution in carrying out your role as an expert. So having just said, be wary of people who are too nice, helpful, or naive, the other point is be friendly. You know, you are meant to be two professionals from the same field. You perhaps know each other already. It's very helpful perhaps if you do. But be friendly and be constructive and help him with his role as much as expressing your own role. And it's always better to open the meeting on a sociable basis. How far has he come? You know, was it a convenient time for him to have the meeting, etc.? You know, is he very busy? What sort of work does he do? And you'll get quite a good feel if you don't know him beforehand. But as I put in italics at the bottom, you're meant to be two professionals coming together to discuss an important subject. It is not a point-scoring exercise. It's not for you to try and show him that you have been in the business longer, know more about it. It's for you to address the points that are going to help this case be heard correctly by the court. So we put it actually on a slide all on its own. Most importantly, be professional.
Sorry, could you just go back to that slide?
Yes.
You put in there talking about how much material you have seen.
Mm.
Is this not... I can see a number of difficulties here.
Right.
If you, as an expert, have seen material and been told not to disclose it, indeed, if you have written material and been told not to disclose it, what are you supposed to say?
I don't know what's not disclosable unless it's covered by the Official Secrets Act.
Well, there could be privileged things. So you could see things that are discussed with your own solicitors and counsel in conference, advices of counsel and so forth. Now those will be privileged. Any communications between solicitors and their own party in which advice is given, all that is privileged and that should be referred to.
Okay, well let me be precise then. I'm dealing with and I apologise if I have already raised this in writing with you. I have raised it in writing with the institution. I'm dealing with a case in Scotland.
Mm-hmm.
I have inspected the product, done a test that I considered appropriate on it, written my report, which has been disclosed to the other side. The other expert, I am told, has done an inspection and a test, and he can't tell me anything about it.
Well,
Am I
I
supposed
would,
to have a meeting?
well, perhaps it's an opportunity for you to put down what your views are and your reasons for it, and it's for him to work out how he supports his view on points of. But the court has charged you
No.
with providing
No,
your reasons
no.
for disagreement.
Well, no, this is Scotland.
Yes.
The court doesn't order joint expert meetings. The
Not in quite the same
parties decide what they want the experts to do, and they can, I understand it there, conduct that he has written a report which they can later produce in court, even though they haven't disclosed it in advance.
So you're an ambush.
I think I'm well up for an ambush, which is why I'm being quite prickly about it.
Yeah, I'm nervous of giving too much guidance because I don't know anything about the Scottish procedures. And as you know, they have a very different, somewhat different legal system.
But I was sort of, I think there may be problem. I can possibly foresee problems within the English.
Well,
System as
what I
well.
would advise you to do,
Mm.
and I'm perfectly happy to say in open forum here, is to consult your solicitor and seek their advice. In other words, do they want you actually to give all the information on the basis that no counter information is being given? And as a professional, are you giving information that's actually going to back up, your reasons and logic? In which case, you shouldn't be frightened of it.
Maybe the other side's findings agree with him and they don't want to say so.
Perhaps they do. Yes. In which case, undoubtedly, it will come out eventually if it ever gets to trial.
That has to be left to the,
Yes.
to the court.
That has to be left to the court. You're seeking to be a professional. You've decided to discuss some things, whether it's been ordered by the court or been put to you by your solicitors, or you've agreed it with the other expert. This is your opportunity to say, I believe this is the case, I've done an inspection, I've done whatever your tests were that involves, and the results were as follows. Use your solicitors as a sounding board, would be my advice. I do very little without my instructing solicitors at least knowing that I'm doing so.
I was going to say that there are different practices in England. There are different practices in different fields of work. In the field of work that I practice in, the parties' experts prepare a report, and that report will have been seen by the other expert before the joint statement takes place. There will be an exchange of reports, and you will know everything that the other expert has said in his report, and the purpose of the joint statement in that context is to see where you agree and where you disagree, and to give the reasons. So the example that you mentioned couldn't really arise in those circumstances, because if they've done some secret test that they're not referring to, then it's not going to be able to be referred to in court because they haven't put it in their report. There is a different practice, though, for instance, in the TCC, in the Technology and Construction Court, where the expert meeting is used at an earlier stage, and the experts may have prepared a